It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined yet again by my co-host, Bro.
Oh, Alice, it feels like some sort of awful case of deja vu. I don't even know what to say about it, but I don't like it.
I don't like it either. Deja vu is exactly right. It feels like we just extensively covered Murdaugh 10 episodes, maybe more.
Extensively.
I mean, it was the last trimester of my pregnancy, and you guys, I'm not exaggerating when I say we finished recording the last episode and the sentence, was given, and I went to the hospital and had a baby. And today is my baby's 6-month birthday, meaning we are only 6 months removed, and we are here to discuss a motion for new trial that has been filed by Pooty-Poot, Harpootlian, the defense counsel for Alec Murdaugh, after he'd been convicted of murdering his wife and son, Neri, 6 months ago. Brett, everybody wants to know how serious this motion for new trial is, what's contained in it, what are the legal standards, and we are going to give all of that to you today because there really is a lot to discuss. And I have to admit, Brett, when I first saw people posting and all the kind of news articles flashing across my screen that said motion for new trial, I dismissed it. I didn't click on any of the articles because a motion for new trial, as we have told all of you before on many episodes before, is filed in just about every case. It is filed in every case where there's a conviction. It's kind of like you take all your different shots. So I didn't even take the time to click on the article and didn't really look at the motion until enough people were asking questions that I thought, you know what, let me scan through this motion for new trial that surely can't contain much substance. Oh, I was a little bit wrong, Brett.
Yeah, I was too, because as you said, you hear about this all the time. They styled it as a motion, newly discovered evidence. And I thought, okay, we're going to have, somebody saw a 4-foot tall 12-year-old running across Moselle the night of the shooting. And that's going to be what they're going to say. And it's going to be silly. And we'll do the press thing. And some people will freak out on Twitter and we'll all move on with their lives. But then when you see what it was, you realize just how serious this is. And it is serious. And I think that's the first thing that we should acknowledge. This is not about the show. This is not about getting Poot out in front of the cameras one more time for his next election to the South Carolina Senate. This is real. This is serious. And it implicates some very fundamental rights we have. And I think this is one of those times where we all have to step back, whatever we think about Alec Murdaugh, and recognize that the most basic guarantees we have are at stake here. Does not necessarily mean he should get a new trial. We're going to talk about the standard, but these are serious allegations. And look, whoever wrote this for Poot, because I'm sure he didn't write it himself, is a pretty good lawyer, and they do a good job on the first page laying out exactly what the allegation is. And so I'm just going to read you this paragraph because if you've only seen stories in the news or if you've only heard things on Twitter, you may not know exactly what the allegation is here. So I'm going to read this to you. Specifically, during trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be, quote, misled by evidence presented in Mr. Murdaugh's defense. She told lawyers not to be, quote, fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with a jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of the deliberations that it, quote, shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. And I'll just tell you, there are no more serious allegations that can be made against a court employee than those. I mean, these go, the oath that we all hold, those of us who are lawyers, those of us who work in the court, to do justice and to do it impartially is very important. And this really strikes at the heart of everything. And if it's true that she was doing those things to the jury, then not only might Murdaugh get a new trial, but she may very well, certainly will lose her job. And number two, should face criminal sanctions if these allegations are true. And we're going to walk through the evidence, the specific evidence of what's claimed here. And we're going to go through each of these allegations and tell you which ones are serious and which ones are kind of fluff. Because some of them are. I mean, some of these allegations are more fluff. They're not as serious, but some of them are very serious.
And kind of at the outset, Brett read you from the really first substantive paragraph of the motion. But what makes this motion, in addition to these very serious allegations, is that it's not just the motion. As you can see, if you've pulled up the document, there are exhibits, and these exhibits contain sworn affidavits, some of them sworn affidavits from jurors who are not named by name. They go by their jury number to give them anonymity, because obviously these filings are public. And as we've talked about, these filings should be public and the public should know what is going on here. Some of these affidavits are by lawyers recounting conversations, but I want you to note that these are not just allegations with no backing up of them. And we'll talk about whether an attorney can go get these affidavits on their own and what force they have within the court of law.
And let's just clear up a few things right from the beginning, because I know, as we often talk about, Alice and I understand intimately the way all this works, and a lot of you guys have no idea. This is a black box for you. The first thing I will say, the jurors are under no obligation to speak to defense attorneys. Often judges will say to the jurors as they're dismissing them, you're under no obligation to talk to either the prosecution or the defense. Either side may ask you to speak to them, because oftentimes lawyers like to hear from jurors. Like, what did you like? What did you not like? What worked? What didn't work? What was the strongest thing we did? What was a weakness? It can really help you going forward, particularly if you have hopes of maybe one day having another trial. In this case, I think initially probably a lot of jurors did not want to talk to the defense. A lot of them were adamant immediately after this, when speaking to the media, that they were 100% solid in their beliefs. But what we did not know at the time is, while all of this was underway, and by this I mean the trial, the clerk of the court, Rebecca Hill, was writing a book. She was writing a book during the trial that she intended to publish when the trial was over. And the allegation in this book came out in early August. And when it came out, it really sort of crystallized things, I think, for the defense attorneys, and I think for some of the jurors who the defense attorneys ended up interviewing. The defense started going to these jurors, asking them about things they had read in the book, about whether or not there was undue influence by this person who was the clerk of the court. And over time, they were able to get some affidavits that we're going to talk about later. That's the thing about this kind of filing. You wouldn't know this the day after. This is something you'd have to suss out. There were things that happened during the trial that were a little quirky. You all remember the egg lady. She comes up in this, and how she was removed comes up in this. And it took some time for them to put this together. That's the first thing. The second thing, the jury, and one of the reasons this is such a troubling allegation, juries are 12 14, including the alternates, maybe more. I think there were 5 alternates in this case. So 17 people. They come off the street. They're put on the jury. They don't know what they're doing. They don't know where to go. They don't know when lunch is. They don't know anything. There are members of the court staff who become very close to the jury. It can be the clerk of the court. It can be the courtroom deputy. It can be the bailiff. It can be some combination of these people. They get to know those people. Those people help them. They help them with all the things that don't have anything to do with the trial. They are never supposed to discuss the trial with them, but they can become very close to the jury. And the jury can see them as a friend and see them as a confidant, someone who, if they have problems, can talk to the judge for them. The judge ordinarily is not doing that. The judge maintains some distance between himself and the jury, and you would expect that. So I think a lot of people are confused about why she would have this access, but it makes perfect sense. There is nothing unusual about her having this amount of access with the jury. What's unusual is that she would then use that access to attempt to influence them.
Absolutely. And to give you some idea of what her job would have been, kind of like Brett was saying, you show up every day and you're given directives from the court, and the judge is the judge, right? You all rise when the judge comes in, and they treat the judge with a lot of respect, but you don't want the judge talking to the jury because you don't want any undue influence there. You don't want things happening outside of the courtroom. Everything has to be on the record. So you have the clerk of the court in this instance, or you have, like Brett said, sometimes it's a judicial assistant. Sometimes it's the bailiff, someone who is with the jury at all times to make sure, for example, that no one's harassing them, that no attorneys try to come up and speak to them when they shouldn't be doing so, to show them where the bathrooms are, because they can't just go wander off by themselves. There's even specific bathrooms that jurors have to go to make sure that they don't run into witnesses, to run into attorneys, to run into anyone who is part of the trial, so that they don't feel any sort of pressure, even if no words are spoken. To give you an example of how close these jurors can get to like their handlers in these situations, when I was clerking, we had an almost 2-month-long trial. Very long trial. It was not a criminal trial. It was a civil trial. And the jury got very close to the judicial assistant who worked for my judge. And she was the person who kind of showed everyone where to park their car, where the refrigerator was to put their lunches if they were to bring their lunch or their eggs, to tell them, which restaurants they could all go to order food for them. They would all decide what food to order together, to kind of make small talk about the weather, because 2 months gets very long and you're stuck with the same 12 or 14 people. And they talk about their kids and their likes and dislikes and their favorite shows and their favorite books. They became so close to the judicial assistant that on the last day of the trial, after the verdict, they had all made matching shirts. So the entire jury made matching shirts, and it had some phrase that the judge always said. I can't remember what it is, but it kind of bonded the group. And they made 12 shirts for the jurors and 1 for the judicial assistant, because she was essentially part of them in terms of how close they felt to her. And she did her job. In that instance, she only did really the administrative things. It's fine to talk to people about anything but the trial, but you can see just how intimately entrenched that person becomes. And those other 12 people, they don't really know what the duties of the clerk of the court are. So you can imagine, as these things are happening in the Murdaugh trial, they may not know that the clerk of the court is not supposed to be having one-on-one conversations with certain jurors in bathrooms, that she's not supposed to be commenting on the testimony. These jurors probably have never served as jurors before. They are lay people. That is what the jury is made up of, lay people. They're not trained to be lawyers. They're not trained to be jury experts. That's the job of the court, to make sure they stay within their bounds.
And let me just say this. Jury tampering is one of the worst things that can happen in a trial. And so there's obviously been a lot of case law about this. We're going to talk about that in a little while. It's actually pretty confused because there's been so much. But one thing that's pretty fundamental, and one thing that I think most people agree on, is jury tampering is always bad. It's always bad when it's about the substance of the case. I mean, for instance, I'll give you an example of sort of a silly thing that we do in our cases. So when we get ready for a trial, when the jury is selected and the judge is giving his initial instructions to the jury, one of the things he'll tell them is, if you see the lawyers in the hall and they don't even look at you, they're not being rude. They're trying to avoid any perception that they might be trying to influence you in some way. So they're not even going to say hello to you. And there would be nothing wrong with saying hello to a juror or smiling at a juror or whatever, but you're trying to avoid any even hint of impropriety. If somebody off the street had stopped one of these jurors as they were walking into the court and said, that Alex Murdaugh, he's absolutely guilty, that would have been a problem. And it would have been something that would need to be talked about. And the judge would have needed to question the juror. And can you put that aside? That's not going to affect you. The fact that a member of the court staff is accused of doing this makes this so much worse. It's just difficult to overstate how much worse it is that someone in that position, it is so far beyond anything that you should see in any case. And the fact that she would do something like this, and look, I totally get it. Innocent until proven guilty, right? I mean, we don't know. All of this could be false, but it's not looking good. We're about to go through the affidavits that the jury mentioned. And the way this is going to go, just to set it up for you, the first thing that's going to happen is a determination. So this is actually a motion to stay because there's an appeal in this case. So jurisdictionally, the trial court has lost jurisdiction of the case. They have found him guilty. They have sentenced him. He has gone off to prison. The trial court's out of it right now. The appeals court has jurisdiction over this case. So the first thing they have to do is actually file a motion to stay the appeal at the appeals court and return jurisdiction to the trial court. And then the trial court's going to have to decide whether or not to have an evidentiary hearing. And I think, based on what we've seen, that evidentiary hearing is going to happen.
With these allegations, I don't see how the court doesn't have an evidentiary hearing. But I think what you note here procedurally is really important. So when a case is happening, there are many courts it can be in, but only one court can essentially be a live play, right? And so the district court right now can't do anything because there's a pending appeal. And that is so there's not multiple contradicting actions within a case. One court has to talk to the other. And I think they will get the stay and it will be sent back to the district court. And once the district court gets it, then they can actually go into the substance of it. So that's really interesting. We've covered a lot of interesting developments in multiple true crime cases that are ongoing across the nation right now. And it's really interesting that we get all of the really meaty, substantive motions in these pretty boring procedural motions, right? This is a boring motion in that it's just, hey, appellate court, can we stay what you're doing? Don't look at, the merits. The appellate court can't actually even look at the merits here in terms of determining whether there is any meat to the allegations. Of course, all of the affidavits and the allegations are included in order to show why the appellate court should stay the appeals and cede their jurisdiction to give it back to the district court for them to determine this. So you can see why there is so much substance within a procedural motion. But this is a very important point because we're going to see many more filings. And this court that received this motion can't do anything right now. And there's many more steps before we actually get to the meat of, did this happen? And
so I know a lot of you automatically and rightly don't trust Poot and Jim. Because, there's so much corruption down there anyway. And a lot of you guys don't like defense attorneys unless they're Bob Murdaugh. And you think they're all sleazy and they're probably making it up and all this other stuff. Number one, whatever the truth is here and whatever is eventually determined by the court, these lawyers are not filing a false motion. The allegations may end up not being true. They may end up not being substantiated. We may have an evidentiary hearing where the witnesses don't stand up, but they believe in this motion. And they have affidavits that they have gotten, which are testimony, sworn testimony under oath. And they are not faking this. They are not suborning perjury. They believe in this, whether it will be proven to be true or not.
Yeah, absolutely. And note, this is not cross-examined. We'll talk about, what actually happens in terms of testing whether this is true. But this is a very serious motion, and it is backed up by affidavits in this instance. Okay, with that all said, let's walk through the allegations, and there are several of them.
Yes. And if you've pulled the thing, they write a brief. It's a good brief. I quibble with some of their law, some of their interpretations of South Carolina law I don't actually buy. But the argument they make is pretty strong, and they follow it up with some pretty good evidence. And the first thing they do, and you often see this, good lawyers lead with their best stuff. And their best evidence is their first affidavit. And it's an affidavit of a juror number 630, who voted to convict in this case. He remained on the jury all the way through and voted to convict Alec Murdaugh. And here's what she says. I'm just going to read you some of the things she says from the affidavit. And I'll tell you what I think's a big deal and what I think's not a big deal. In a few minutes, once we get through sort of giving our views, we're going to get Bob on here and he can give you his. But here's some big deal things that are in this sworn affidavit that if there's an evidentiary hearing, obviously this person, they're going to have to, they're going to have to get on a stand and repeat these things. But this is what they are alleging. Towards the end of trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including look at his actions and look at his movements, which I understood to mean that he was guilty. Now, put aside her editorializing at the end about what she took that to mean, though that will be important. If those allegations are true by themselves, if she did that, those things, that in of itself is a huge problem and is potentially grounds for a new trial. She should not have done any of those things. They are incredibly prejudicial, particularly coming from her. And she would have known that this was not an accident. I think that's another important thing. If she did this, she would have known exactly what she was doing. And we're going to talk about more stuff. That alone, what we just told you, may be enough to get a new trial. And I'll just tell you, if you look at the case law, the cases that deal with this kind of stuff, it'll be things like a bailiff makes an offhand comment to the jury. And that ends up going all the way to the Supreme Court of South Carolina about whether that's enough to overturn a conviction. This is so much worse than a bailiff making some offhand comment.
Right. And the offhand comments are literally like that. A cough like, oh, gosh, as opposed to actually commenting on the strength or the veracity of Alec Murdaugh's testimony. And again, I think that is so key here. The affidavit doesn't just say what the juror number 630 thinks it meant, but there are quotations as to what this person remembered Rebecca Hill saying. Remember when we were talking in our 10 episodes, the jury is not supposed to discuss with each other or anyone else any of the testimony, any of the evidence before the case is submitted to the jury for deliberation. That is incredibly important. We said that many times. So every time they take a break, they're supposed to go back and talk about anything but the case, or talk about nothing, but they cannot talk about the case even with each other. They certainly can't talk about it with the clerk of court. But here in another line of the affidavit from juror number 630, this person also says that after Alec Murdaugh testified, the foreperson, juror 826, said Mr. Murdaugh was crying on cue. If that is true, that isn't tampering there, but that is also something that should not have happened within the jury, because we know that they can't talk to each other ahead of time. And if it's right after Mr. Murdaugh testified, then we know that's before closing and before the jury entered deliberation.
And I think, look, that by itself is not going to result in a new trial. You might file it, and it might be frowned upon, but the sort of no harm, no foul analysis of harmless error that eventually will happen would deal with that. But I think the reason they include it and the reason it's important is it goes to sort of the atmosphere in that jury room. And one of the things they say happened is that Hill would go, and there's stuff in the affidavits about this, that Hill would go into the bathroom with the foreperson and they would talk for 5 or 10 minutes. And then they would come out and not say anything to the jury. And so the fact that the foreperson is having these conversations and saying things about the case as it's going on, we don't yet know for certain. They will be questioned about this in any evidentiary hearing. But the fact that they're doing that, you tie those two things together, and what does it sound like is happening? It sounds like he is her agent. He is now helping to advance what she wants to happen. And the whole reason she's doing this, she's writing the book, and she knows if he's acquitted or if it's a hung jury, she doesn't have an end for the book. It can't go that way. He needs to be convicted for her book to work. And remember, she is she used to be a court reporter. She got elected to clerk of the court in Colleton County. This is so much bigger than anything that ever happened in that county. Worldwide attention is on this case. And if this is true, then you can imagine what she was thinking. This was her chance to live her dream, to be on the Today Show, to be in these documentaries, to write a book that becomes a bestseller. And who knows what she might be able to turn that into. That is what's driving what's happening here.
Yeah, I mean, there's probably another case that has reached this level in the Colleton courthouse, or really any other case. Why did we spend 10 episodes talking about this trial that had everyone around the world on the edge of their seats? Because this was the stuff of movies. And here's the thing. The jurors, of course, they can talk to the media afterwards. No, there's no gag order on the jury after they have their verdict. But no one understands the law and the court and has access to the jurors who are the ones deliberating as Rebecca Hill. And so those of you who are wondering, why would she do this? For everyone situated within the courtroom, there's actually no one better to kind of have the tell all than her. The judge doesn't have that, nor do judges typically engage in, these books after the fact. But the judge isn't back there with the juries. The attorneys, they can tell their side of it, but they're not back there with the juries. They don't know what's going on. What's important and what's riveting about this case after the fact is what the cameras could not catch. And what the cameras could not catch is what happens behind closed doors. And who had access to those closed doors? Rebecca Hill. And so she is uniquely situated to profit off of this case. We're not supposed to, and that's why there are regulations and laws in every state, including South Carolina, that prevent court officials from using their position to profit. And that's because we need to be able to have positions within the courthouse that hold these important powers. And if people are doing this left and right, I mean, there is a lot of problems with our constitutional protections.
And I think that's so important. And like I said, I know a lot of people are going, and including me, are going to be inclined to say this is not a big deal. He's obviously guilty, et cetera, et cetera. But juries aren't kabuki theater. We don't do it just as like a show trial. We do it because they're supposed to be the ones making the decision without outside influence. The reason we have all of these rules of evidence, the reason we had multiple arguments outside the presence of the jury about what should come in, the reason we had multiple days of testimony the jury didn't even hear, just so the judge could decide what comes in and what doesn't, is because we believe that these cases are supposed to be decided on admissible evidence alone, not the opinion of the court clerk. And look, jurors are trying their very best to figure all this out, and they actually are pretty susceptible to this kind of stuff. When they're hearing somebody who they see as someone in a position of authority, someone who has worked in the court, someone that they trust, and they're telling them, look, you're a juror. This is your first trial. This is my 1,000th trial. That guy's a liar. You shouldn't trust him. That is going to have a huge effect on how they view the case.
And remember one other thing, the jury is instructed and they're not supposed to be listening or consuming any sort of news analysis on what's happening. They're not supposed to watch the news. They're not supposed to be on social media. They're not supposed to read anything about the case. And so think about it. Whenever you hear something, for example, this filing, what do you go do? The first thing you do is to say, is some podcaster doing some analysis of this? Is there some news article about this? What am I supposed to think about this? That's what we all do when we are faced with having to be a decision maker in an area that is not our expertise. We kind of look for people to help guide us. And so the jury members, they're not consuming news media. They're not listening to Bob Motta talking every day after the testimony, talking about, this person shouldn't have said this. They don't hear any of that. All they hear is what happens in the courtroom. And the courtroom itself is devoid of any reactions, as it should be, right? There's not a laugh track. There's not gasping. In fact, the judge had to admonish certain people in the gallery who were watching the trial who had too many facial expressions, right? Buster, for example. And the reason the judge did that is because you're not supposed to have any reaction in the courtroom that may shade how the testimony and the evidence is received by the jury. So think about this. We are so shaped in our lives and how we receive and analyze information based on people's reactions. Think about the classic example of a baby. You're holding them and you'll see lots of like TikTok videos or YouTube videos or whatever of someone knocking the wall and not hitting the baby's head, but pretending and reacting like the baby's head was hit, and they make a loud sound, and then the parent like goes, the baby immediately starts crying because they are receiving inputs from around them and reacting like they think they should. The parent holding me just freaked out. Therefore, something terrible must have happened, so I'm going to start crying. That's a baby who hasn't been trained in this world to understand all the analysis of the world. It is just human nature to take in the reactions around you, especially of those who should know better. And in this instance, the jury is listening to cold, hard evidence, no reactions by anyone in the jury room, no laughing, no gasping, no analysis. They're not reading any sort of news media analysis after the fact. They are sequestered. They are not supposed to talk to anyone about this case. And here you have Rebecca Hill making a small comment that a juror may not at the time recognize is tampering with the jury. This is why her comments are so bad.
And, you know, just to address quickly things I see in the chat. Number one, she's alone with them because that's her job. You know, we trust the clerk of the court not to do these things. You don't have to have 3 or 4 people in there to make sure nobody's messing up. This is a small county. They don't have a huge staff anyway. We trust her to do this. This is her job. She takes an oath. There are criminal consequences for this if she did this. So I get it. It's too bad that she was the only one in there, but that's the way it works. Number two, why did the jury not report it earlier? The jury didn't necessarily know any of this was improper. They see her all the time. They hear the judge saying, don't talk to anybody about the case, but they don't necessarily think that the clerk of the court is that person. They don't necessarily know until she writes a book and a defense attorney shows up on their door, and they may just, and they're like, yeah, you know, I really didn't think you did it, but I was talking to Becky and she said this, and I thought, yeah, that's a good point. And the defense attorneys are like, what? What happened? You know, they may not even understand. They don't know all the rules. So it's not necessarily surprising to me that it took a little while for the light bulb to go off for them, or at least some of them. Oh, this is problematic.
And remember, the reason, and we see this a lot, not just in juries, but in any sort of decision making, when you've rendered a verdict, the jury, of course, wants to stand by it, not because they're trying to cover up any malfeasance, but because we as people want to make sure that what we've done, which is sending a man to prison, was rooted in all the good things, right? All the constitutional protections were at play here. And of course, you want to defend your decisions, whatever they are in your life. And we see this with juries all the time. They don't want to talk to anyone about their verdict. It's not usually until sometime later or some new information like we have here with Rebecca Hill's new book that juries will start to say, well, you know, I actually did feel pressure to change my decision. And I want to address something else because I know this conversation can go on for a very long time. A lot of people have said, okay, so this is really bad. What Rebecca Hill did was really bad. This looks like the newly discovered evidence was tampering. Who cares? Alec Murdaugh is so clearly guilty. He admitted to all these sorts of things on the stand. Whatever. We'll have a new trial and he will just be convicted again. Big deal. Here's why. This is a 6-week trial. There were incredible resources poured into this trial, not just money. It is literally years of investigation and years of hard work and a lot of money to prep up this trial, not to mention 6 weeks of the court's time and all of the witnesses and everything that goes into having a 6-week trial. And we've talked about the jury being a black box. Not only is this a cost thing, this is not just it's just money. It's just money. We just have to have another 6-week trial and it will render another guilty verdict. Now, everyone's had sworn testimony. The defense essentially has a playbook of what the prosecution's going to do, and they have sworn testimony to be able to cross-examine every nitpicky word that is slightly off the second time someone testifies. That is a huge deal, because guess what? When you testify, when you speak under oath, when you speak in general, even when you are speaking the truth, it is almost impossible to verbatim say what you have previously testified to. And that's actually a marker for us when we're kind of interviewing witnesses of someone who's telling the truth, when their story changes ever so slightly the next time they tell it, because they're not memorizing a script. But because of that, there are going to be a million things with every single witness that the defense can cross-examine them on and essentially make a sideshow with the jury as to whether each of these witnesses can be trusted. And that may play very differently with a new jury, when now every single witness, instead of just having to think about whether you believe what they've testified about, there's this whole other trial happening of, well, last time they said it was 15 minutes. Now they're saying it's 12 minutes. 3 minutes is a long time. What can we trust about for anything? And that's not the only thing. They also said it was 5 feet. Last time it was 3 feet. What are they just trying to change their testimony now? This can have a very serious effect on whether jurors put credibility or give credibility to certain witnesses. And times 6 weeks over, it could very well play incredibly differently. And also, we know from this particular jury, some of them had questions about whether they should render a guilty verdict. So even if the evidence to us on the outside seems slam dunk, he's going to be convicted again, I think we have words from the jury in this very matter that they weren't completely sure. And you would expect that in any case, especially when it's as serious as sending a man to prison for the murder of his wife and son. So I just want to address that really quick, because this is not as easy as let's flip the switch. Everyone take your roles again. Let's pull out the scripts. Let's go 6 weeks again. And we're just going to end up in the same place with a new jury. That's not exactly how it works.
Yeah, and I'll just point out a few things. Number one, finding a impartial jury at this point is going to be even harder. It's kind of like in the Casey Anthony case. You ended up with weirdos because the only people who'd never heard of the case were people who lived in caves or whatever, right? And some of the prosecution was like, yeah, we had this jury that basically, the only people on the jury are people who'd never heard of it. And who are those people? And so you're going to have a similar problem. It's a small county. It's going to be hard to find people who don't already have their minds made up. That's the first thing. The second thing, somebody said, yeah, but the defense will have the playbook too. No, completely different. The prosecution has the burden. The prosecution has to prove everything. The prosecution can't just change up its strategy next time. The defense can. The prosecution has to put this case on again with the exact same witnesses. In the press conference, you had Harpootlian say one of the SLED agents perjured themselves because he made a mistake at grand jury, which he admitted on the stand. But that's what he will do. And now it's not just going to be one SLED agent with grand jury testimony. It's going to be every single person who testified. The other thing, in this trial, Alec Murdaugh testified, he lied, and he got caught in it. And that was important evidence that could be used against him. This next trial, unless he's a complete moron, which he may be because he's so full of himself, he will not testify. And he will not set himself up for that. And the jury will not have that very powerful evidence of guilt that this jury had, and it very well could make a difference. Look, I don't want to go through every single thing in here because we'll be here all night. To suffice it to say, there's a few things. There is another affidavit that is not by a juror, but by someone who spoke to a juror. It's a little weird. The affidavit basically says they couldn't get it set up for this person. Makes me question the affidavit. But in the affidavit, the person who interviewed her says, or him or her, whoever it is, that before the defense put on the case, Hill said, y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you. The other affidavit is from Egg Lady, who you may recall was kicked off the jury, who had the eggs back in the room. A lot has been made of that. Actually don't find that convincing at all for a couple reasons. Number one, it seems to me that the things that happened there could very easily just be confusion. For instance, they found a Facebook post by a person who has the same name as her ex-husband. That could have just been a mistake. And it wasn't just the Facebook post that got her kicked off. She had told other people that she had already made up her mind as well. So not a big deal. The issue is going to be these first two jurors and their affidavits.
And I think this is really important because it's kind of easy to seize on the egg lady thing and say, see, we got someone kicked off who was going to vote not guilty. I want to note that the reason I don't think it's going to be a big deal is whatever Rebecca Hill was doing, if she made up the Facebook post, if she questioned the juror without the court there, note that the juror in her affidavit said to the judge after she was excused, is this because I talked to Rebecca Hill? And the judge said no. So I don't think what Rebecca Hill did, if it's true, is still terrible. But I think there were independent reasons. And we've talked all the time about harm. Like, what's the harm? If there were other reasons for her to be excused other than what Rebecca was trying to do, then there's kind of the no harm, no new trial sort of situation. But the other jurors' allegations of what Rebecca Hill said, that is harm. A lot of harm.
Absolutely. And there's going to be so many interesting legal questions in this next trial if it happens. But okay, so before we put Bob on, because I want to hear Bob's views on this right after I pick, I think the Bengals defense is what I'm going to go for. Bengals over.
Okay, while you do that, let me just tell people the legal standard in case we've said this.
That's what I was going to say. We're doing the legal standard.
Okay, let's do the legal standard while you pick whoever it is. I'll carry the water here, Brett, while you make sure you have the right team. So the standard here, and there's always a legal standard section in the motion. You can go read it. I think they kind of take some liberties with it, and they maybe go a bridge too far, but with that all said, a motion for a new trial based on after discovered evidence. And the reason it has to be after discovered evidence is typically you have to file a motion for a new trial within 10 days in South Carolina. That's pretty typical. There's a short amount of time because there's been all these resources that have been expended. And basically you want to get to the next court. You want to get to the appeals court, which is where the case currently is now. But obviously, if you have newly discovered evidence, you can't have perhaps found it within the 10 days. So South Carolina says you have to file a motion for new trial based on newly discovered evidence within a year of finding out the new evidence. We are well within that time frame because the book came out, I think, August 1st, something like that. This motion was filed basically within a month of that. That is actually pretty fast. By the way, this is why I kind of have some questions about the affidavits with regard to the attorneys who said what they heard from a juror as opposed to the jurors themselves. They weren't up against some sort of statute of limitations or, the year mark. And so I can imagine if they were on day 364, they had to get this motion on file, but maybe that juror was out of the country, sick in the hospital, whatever. They literally couldn't get to the juror in order to have the juror swear to the affidavit and sign it. I can understand in that situation why someone else who heard what the juror said signs the affidavit. In this case, we still have many months. Of course, these are very serious allegations, and they want to make sure to get it on file while maybe the public media is still interested in the Murdaugh case. But I am a little wary of the affidavits that are not signed by the actual jurors themselves, because we know that South Carolina allows this motion for a new trial within a year of the discovered evidence. Now, I would say a lot still needs to be discovered, as we can tell based on the allegations here.
And so they're going to have an evidentiary hearing. I have no doubt about that. And maybe all these people will come in and they'll say, no, she didn't say any of that. That's ridiculous. Maybe the juror will say, well, I didn't hear her say that, but I heard somebody else say something that I thought was her saying that. And so I put it in the affidavit because I thought that's what she said. There's no telling what will happen. As we've talked about in other cases, affidavits are great because they're not cross-examined. And you're not sitting in the witness chair having to say in front of Judge, God, and the entire media from around the world exactly what happened. It's possible they have an evidentiary hearing and they just find these allegations aren't credible. And since they're not credible, no new trial, we move on. But let's assume for a second that they are credible. It did happen. Assume that for a second. Assume the worst case, that Hill was attempting to make this happen. There are a few cases that govern this. There's a Supreme Court case called Rimmer versus United States. It is from 1954, and it's supposed to set the standard for how this is handled. There is so much ink that has been spilled on how no one really knows how to deal with Rimmer and how to apply it. And so every state and every district has a different rule. In South Carolina, there's also some confusion. And if you read the brief, you know this. The defense really grabs on and hugs tight this 1993 appeals court decision. And there's a reason for it, because it says something that, if this is the rule, means Alec Murdaugh's going to have a new trial. And I'll just read what it says. So in this case, it says, when there was private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted, unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. That is as high a standard as you could possibly have. That is essentially a structural error standard, that if there was a communication with a court official and it was about the trial, new trial. I mean, that's essentially what it says. And certainly her communications under that standard would result in a new trial. So if that's the standard and the court finds that she said these things to the jury, there's going to be a new trial. Now, that was 1993, and that's a very broad statement. In 2020, there was a South Carolina Supreme Court case called State versus Green. And it's funny, as I said earlier, these all deal with bailiffs, and this one dealt with a bailiff as well, who said something to the jury. And they don't seem to have that high a standard. And they go back to this Rimmer case and basically say it's Rimmer that's going to govern. And if Rimmer governs, which is the United States Supreme Court, so you think it would, the way it would work is this. If she had that conversation with these jurors, then you would go to the presumption. There will be a presumption that there is prejudice and we have to have a new trial. But it is a rebuttable presumption, but it is one that is heavy. And this is what they say. The presumption is not conclusive, but the burden rests heavily upon the government to establish that such contact with the juror was harmless to the defendant. So basically, if she did this, what you would need is every one of those jurors to essentially say, yeah, she said that, but I didn't listen to her. It didn't matter. There was so much evidence. It was huge. Obviously, he was guilty. Doesn't seem like that's what they would say based on the affidavits of these two jurors, but you never know. And that's going to be part of this evidentiary hearing. There's going to be two parts of it. Did she do it? And if she did it, can the government prove that there was so much evidence against him and the jury really just considered that evidence and was able to put what she said out of their mind? Is there enough of that to maintain the conviction? I think that's going to be a really, really difficult thing for the government to do, given the number of communications, the explicit nature of these communications. It's going to be tough. It's going to be tough if it turns out that these things are true.
Whew. So with all of that said, the allegations are serious. I do think an evidentiary hearing will happen here, but there's a lot. That evidentiary hearing will be big, and it will probably be very long. And like Brett said, I can't emphasize this enough. Even though there are affidavits in this case, they are untested. There's no cross-examination. They're not even under questioning. They were written by somebody else. Even though the person signs it, these affidavits, just so you know, are probably written by the attorneys. There's nothing wrong about that. It's because the attorneys want to make sure they get the right words, and they work with the witness typically. Are you sure this is what they said? But it's going to be the words of the attorney. It's very different when someone takes the stand and has to articulate without an attorney putting words in their mouth, as an attorney is doing when they write an affidavit for someone. So it's very possible that a lot of this falls apart when someone's on the stand. It doesn't mean that these affidavits here are fabricated. It's just that people tend to be less specific until tested under oath with cross-examination. So I just want to note that this is very serious. And if true, it is serious. But hold kind of judgment until we hear what happens at what I think will be an evidentiary hearing. So write to us at prosecutorspod@gmail.com or find us on Facebook, Instagram, Twitter. Thanks for joining us for this really, really interesting discussion. There's going to be a lot more to come, and we hope you will join us for it. Until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. don't know. It's overworked.
I'm sure that's what it was.
You know what?
That's what
Just like me, it's overworked is all I've got to say. I'm so tired.
And now your internet's kind of like slow too. You're just having all sorts of problems, Alice. What in the world?
Am I frozen? Am I good now?
You're not frozen. You're just kind of jumpy. But it's, whatever.
Okay.
It just makes it more interesting to try and understand you when we can only hear like every other word.
Everything is exactly set up like yesterday.